Good afternoon, everyone. We'll go ahead and get started with thank you all for being here today. What we're going to be discussing during the next hour are things that you as employers need to know about the new United States Department of Labor salary threshold rule. This is a new rule that came out from the the federal Department of Labor Wage and Hour Division, specifically about overtime requirements. And so that's what we're going to focus on today. So I'm Beth Langley. I am a labor and employment attorney with Brooks Pearson. I'm so pleased to be here with my colleague, Erin Barker. Erin practices in the labor employment area as well as ERISA employee benefits and some M&A transaction work. So she's definitely has some great insight for the topics that we're discussing today. So just kind of as a agenda, what we're going to go through, we're going to talk about the Federal Fair Labor Standards Act's exemptions, the non-exempt classifications and exempt classifications. We're really going to hone in on what we refer to as the white collar exemptions, executive, administrative, and professional, and that's what we call the EAP. And then this is an acronym filled session. The HCE exemptions, highly compensated executives. So we're trying to pick up the lingo from the Department of Labor, the DOL. We're going to give you some background on this new rule. The first phase of it went into effect last month, so we'll start with that, and then what we can anticipate happening in January. We're also going to give you what we have seen to date on some enforcement activity, and also just some best practices, because we're hoping that as a result of just putting this awareness up here, you're going to take a look at how your employees are classified as either exempt or non-exempt from overtime. And you may find you need to make some tweaks, and we'll talk about how to do that. We've got a lot of content. So we really encourage you, if you have a question, to put it in the chat. But what we'd like to do is we're going to reserve about 5 minutes or so at the end, and we'll go through those questions. But feel free to have as you're thinking of them, put them in the chat, and we'll cover those. Just as a disclaimer, this is general information. We're not consulting with you, on any matter specific to your organization. And also, if you put information in the chat, just make sure that it is not, it doesn't include facts that are specific to your organization. We, just kind of put some generic information. We don't want to disclose confidential information. Also, we want you to be aware that this new salary threshold rule is currently being challenged all across the country, multiple federal court cases. So there's a possibility that, some of what we covered today, not all, but mostly just the salary threshold piece, there may be some changes to that by the courts, but this is where we are today. And we're just advising clients just to take a look and be prepared. So with that, we're going to start off with just some basic overviews of what are these FLSA exemptions. So as a general rule, most employees are going to be non-exempt, meaning that they are eligible for overtime for hours worked over 40. Most every employer, if you've got 2 or 3 employees, and as long as you're engaged in interstate commerce in any way, you're covered by the Federal Fair Labor Standards Act. So when we start talking about whether someone is exempt or whether they're not exempt, what we're really talking about is, do the minimum wage and overtime provisions apply to that particular employee in their job? Also, just want you to be aware, we're only covering the federal aspect right now. Many states have their own wage and hour statutes that have even stricter exemption classification requirements for folks to be exempt from overtime. So if you if you have employees in multiple states, just make sure you're getting some legal advice of complying on that state side as well. So as I mentioned before, the kind of default rule under the Federal Fair Labor Standards Act is that employees get overtime at the rate of 1.5 times their regular hourly rate when they work more than 40 hours in a work week. And for determining overtime, everything is based on that work week. It's not a pay period. It's not, averaged over a period of time. It's, each week stands alone. And employees are only going to be exempt if they meet very specific statutory and regulatory exemptions under the Fair Labor Standards Act. So a lot of times we hear, we get a question from a client and they'll say, well, this person doesn't get overtime because they're paid a salary. Being paid a salary does not determine whether an employee is eligible for overtime. The essence of their job compared with the regulatory requirements makes that determination. So unless an employee fits within one of those very specific, what we call exemptions to overtime, then they must be paid overtime at 1.5 times their rate for any time worked over 40. And we have to take into account other forms of compensation and figuring out what that, it's 1.5 times what, what is that regular hourly rate? So which employees are exempt? I'm going to give you the broad overview and Erin's going to drill down into that. So we're going to focus today on what we call the white collar exemptions, and the ones we're going to talk about more in depth or what's called the executive. We talk about that. We're in acronym land again. Administrative employees, professional employees, those highly compensated. We're also going to discuss the computer professional employee exemption and just what that means, and a little bit into what is an outside sales employee who could be exempt. So there are other exemptions, but these are the ones we're going to focus on this afternoon.
Thanks, Beth. So as Beth mentioned, I am going to drill down into just a few of those exemptions, and those are the EAP and HCE exemptions, the executive, administrative, professional, and highly compensated employee exemptions. And of course, as Beth mentioned at the beginning, this is a general overview. So each of these exemptions have nuances to them. There are, of course, like guidance and case law interpreting all the regulations dealing with them. So anything we say about these exemptions, of course, there's probably more, but we just don't have time to get into all of the nuances today. So if you have any specific questions about your employees, please save that for council, and please save like general questions for the chat. So for the EAP or HCE exemptions, there are 3 tests that have to be met. There's the salary basis test, the salary levels test, and the duties test. If you don't meet one of these tests for a position, then that position is going to be non-exempt. And the salary basis test is sort of the threshold. That's where we get into that common misconception of, oh, we're paid on a salary and so we're exempt. But again, this is just one of the tests. Under the salary basis test, an employee is paid on a salary basis if they're paid a set amount, what we know as a salary, each paycheck on a weekly or less frequent basis. That means weekly, bi-weekly, the middle of the 15th and the last day of the month, even monthly, but it's not daily. And so there was a recent Supreme Court case, Helix Energy Solutions Group. This was a case where there was an employee who was like an oil industry worker, and this employee was paid a lot of money. It was around $200,000 a year. but his pay was on a daily basis. So he was paid something like $960 per day. He was paid weekly, but it was calculated daily. And so this went up to the Supreme Court on the question of, okay, well, does that count as a salary basis? He's paid weekly or monthly. He makes $200,000. He may or may not satisfy the duties test, but we'll get to that later. And the Supreme Court said, no, he's non-exempt. And so because he's not paid on a weekly or less frequent basis, his pay was calculated daily, that didn't count. And so I'm not sure exactly how much overtime he was owed, but if you picture, an oil rig worker, there's probably a lot of overtime because you're out there working a lot.
And the key here is that you have to guarantee at least a minimum amount of salary. So you have to guarantee like what we'll often referred to as a base salary that meets that threshold each week. But doing it on a daily basis or an hourly basis will not meet the.
Yeah, so that salary can't be subject to reduction based on the quality or quantity of work performed. So like, if you're paid on a daily basis and you work 6 days that week instead of 7, then that salary is reduced by that day. And so that wouldn't count. This is also the salary basis test is where we get into wage deductions and what deductions from exempt employees' pay are permissible and not permissible. That gets really tricky. There are very limited exceptions for when you can deduct from an exempt employee's pay. And so we would, of course, recommend consulting with counsel if you're worried about deductions from wages and ensuring that those are done properly, because if you deduct from pay and it turns out it wasn't a permissible reason under the statute, you can lose the exemption for that whole group of employees, everybody in the same group, even if you meet all the tests. And so that's definitely something to keep an eye on and be careful of. So that was the salary basis test. Next, we have the salary level test. So you have to be paid at least weekly or on a weekly or less frequent basis at a certain level. And so the salary level test sets that threshold. Before July 1st of this year, that level was $684 per week for the EAP exemptions. And then it was $107,432 per year for the highly compensated employee exemption. This is the rule that has changed recently. So a new rule was finalized effective July 1st of this year that increased the salary level for the EAP exemptions to $844 per week. That comes out to just about $44,000 per year. It's $43,888. For highly compensated employees, the annual salary increased from around $107,000 per year to $132,964 per year. So you may have had discussions about this internally, or you may have talked with counsel about this. As of July 1st, these are the thresholds. And so employees either need to be making at or above these thresholds now to continue to meet the exemptions. January 1st, we have another change. It increases again to $1,128 per week for the EAP exemptions, and then a big bump up to $151,164 per year for the highly compensated employee exemption. And so this is, kind of a bigger stretch for some employers to bump up employees' pay to meet these exemptions. And so this is where we're having conversations about, can we increase salaries, or do we need to potentially look at reclassifying employees who were exempt and who now would be non-exempt because they just won't be able to meet the salary level test? Then July 1st, 2027, and every 3 years after that, it's set to increase again. And so we don't know exactly what it'll be. It's going to be based on then current earnings data. There's calculations and formulas and methodology that are described in the final rule that will be used to increase the salary levels. And the idea is the salary levels will increase as, pay increases and the economy changes. And we have yet to see, whether this will go into effect because, of course, it's being challenged, which we'll get to in a little bit. One thing we wanted to note, though, is special for the computer professional employees. So as you saw, currently, it's $844 a week for the executive, administrative, and professional exemptions. Computer professional employees, however, have a special rule where they can get paid salaried or hourly. And their hourly pay hasn't changed under the new rules. So they can still be paid $27.63 per hour. So if you have employees who are exempt under the computer professional exemption, it's worth taking a look at whether that employee should be paid a salary or hourly and what amounts it would be. It's definitely one of the trickier exemptions to calculate and to figure out whether you meet all the tests. So we just wanted to flag that that amount had not changed. Another note on incentive compensation, Beth mentioned earlier, trying to figure out what goes into calculating the rate of pay and how much someone might be owed over time. That can include things like commissions and incentive compensation, but incentive compensation is also important for exempt employees. So some employees' pay may include non-discretionary bonuses or other incentive compensation. Think things like commissions or performance-based bonuses where the employees are given a goal, and if they meet that goal, they get the bonus. This isn't something like, the annual holiday bonus or, the company did well, so we've decided to give a bonus, but we don't have to every year, those discretionary things. These non-discretionary bonuses and incentive comp like commissions can somewhat or partially count towards the salary level. It's up to 10% of the standard salary level can be satisfied with these incentive compensation payments. And sometimes those are calculated quarterly or annually. And so you might not know, each week or each month whether you've met that level. And so at the end of the year, there's an opportunity to do a catch-up payment. But incentive comp can get complicated, and of course, there's a lot of nuances and details to it that we just aren't going into in this presentation. So if you have questions about whether your incentive compensation is structured in a way that complies with the FLSA and making sure you're meeting that salary threshold, please reach out to counsel.
And I would just add one more thing on that. If you pay, either commissions or bonuses throughout, non-discretionary bonuses throughout the year, monthly, quarterly, whatever, then please make sure that you're working with counsel to make sure how you calculate that regular hourly rate, because it has to be factored in.
Yeah, that's a good point, even for the non-exempt employees. All right, so we've talked about the salary basis test. We've talked about the salary level test, and then the final test is the duties test. And this test is different for each exemption. So, all EAP and HCE employees have to be paid on a salary basis and have to, meet the salary level, but then each one has a different duties test. And so we're going to give a general, very broad overview of what those duties are for each of these exemptions. For the executive exemption, the employee's primary duty has to be management, and they must customarily and regularly direct the work of at least 2 or more other full-time employees or their equivalent. And when we're talking about 2 or more full-time employees or their equivalent, that can be, 2 full-time employees, that could be 4 half-time employees. But what's really important is sort of the assistant manager dilemma, right? Or the multiple managers dilemma, which is you can only count 1 employee towards 1 manager. So if you have, 2 full-time employees and 2 managers, they're not going to be able to meet this test because each manager is not going to be independently, regularly directing the work of 2 or more full-time employees that the other one is not, right? You can't count them. You can't sort of double dip on who you're counting for managers. And when we talk about managing and directing, that means that the executive exempt employee has to have authority. That's authority to hire or fire or promote or advance or transfer those employees. Or if they're not the ultimate decision maker, their suggestions at least have to be given particular weight. And particular weight means that the ultimate decision maker is actually listening to the suggestions or requesting the suggestions. And it's done regularly. It's not sort of a one-off comment. This executive employee is actually like actively involved in managing these employees. So we mentioned the assistant manager dilemma earlier, which when we're looking at assistant managers, this is a really common issue that we encounter where someone is given the title of assistant manager, but really they're a working supervisor who's doing day-to-day activities alongside the employees and may have some management duties, but really they don't have the authority, or they're not spending, the majority of their time on those management duties, or their management duties just really aren't as important as actually getting the work done. And so if you have assistant manager positions, it's really important to take a look at what the responsibilities are rather than what the job title is. Next, we have the administrative exemption. So this is the A in EAP. For the administrative exemption, the primary duty has to be office work. It's got to be related to management or general business operations. And it has to involve the exercise of discretion and independent judgment with respect to matters of significance. And these are all defined terms. This is one of the most commonly misapplied exemptions. The tendency is to, see the word administrative and think, oh, well, office staff or administrative staff are exempt because they're doing administrative work. But the key is really the discretion and independent judgment. This is high level sort of management work. This is, the director of HR compared to the rest of the HR department, or, the highest level sort of billing or accountant employee, as opposed to people who are working at someone else's direction. So administrative employees will perform work such as tax, finance, accounting, quality control, purchasing, personnel management, managing employee benefits, labor relations, public relations. It has to involve, making decisions and implementing policies, not just carrying out those policies that someone else has come up with. Next, we have the professional exemption, so the P and the EAP exemptions. There's a couple different subcategories. There's learned professionals and the more artistic professionals. But basically, this exemption, the primary duty is work requiring advanced knowledge. So it's typically intellectual work. It must involve the consistent exercise of discretion and judgment. That advanced knowledge must be in a field of science or learning. And the advanced knowledge must be acquired by a prolonged course of specialized intellectual instruction and certification exams. So this is most often seen in engineers, doctors, lawyers, CPAs, although it's important to note that just having the title or having the degree doesn't let you meet this exemption if you're not actually using it and applying it to exercise discretion and judgment, right? So just because someone has a CPA certification does not mean that they're using it, right? And see, this is, again, you have to look at the actual duties and not just the job title or, the requirement that the person have a certain certification. Next, we have the HCs, the highly compensated employees. These employees are performing office or non-manual work. So this is not manual labor or blue collar work. Again, these are the white collar exemptions. And these employees must customarily and regularly perform at least one of the duties of an exempt administrative, executive, or professional employee. So this might be someone who, you know, exercises discretion and independent judgment in one area, or maybe manages one employee, but not two employees, right? Like it's sort of like a combination where you can pull from different duties here. As a quick overview of computer professionals, as we mentioned earlier, these employees can be paid on a salary or hourly basis. So this is a little bit different from the other exemptions. If paid a salary, right now it's a basis of $844 per week under the new rule. But if paid hourly, the rate hasn't changed. It's still $27.63 per hour. For their duties tests, computer professional employees have to be employed as a computer systems analyst, a computer programmer, a software engineer, or another similarly skilled worker in the computer field. So IT help desk roles typically are not going to qualify, or servicing or repairing computer hardware is typically not going to qualify. The primary duty has to include actually applying systems analysis techniques and procedures. So this might be user consultation. You know, if it's a systems engineer, it's typically working with hardware. If it's a software engineer, it's typically working with software specifications. But it requires designing, developing, documenting, analyzing, creating, testing, you know, modifying computer systems and programs, or machine operating systems, or some combination of the above. But it has to involve skills and computer skills. It's not just working on computers, and it's not just working with computers, right? So some jobs are highly dependent on software. Some jobs require proficiency in multiple computer systems. You know, if you think of the basic like Microsoft Suite, right? Just because you're proficient in using Excel and your job requires you to use Excel doesn't mean you qualify as a computer professional, because you're not programming or designing or developing or implementing computer systems. It's also, it'll come up sometimes in like people who use design software, like engineers or architects or graphic designers, those sorts of roles, or marketing roles perhaps. Just because the person is using a software doesn't mean that they're designing and developing and implementing it. And so this is a tricky one. You know, we will sometimes see an IT department that's entirely classified as exempt as computer professionals. And chances are some of those people are more so like help desk roles who are incredibly important to the work, but they're like following a documented troubleshooting guide or following documented procedures that someone else has designed and created that documentation. And so it can be tricky. And it's really important to look at what the actual duties are and not just the job titles. Next, we have outside sales. And so this isn't included in the EAP or HCE exemptions. Outside sales is a little bit different. It does not have a salary basis or salary level test, but it does have a very important duties test. And that duty is the employee must be making sales. So this is actually soliciting sales, even if they're not the person signing the contract. Ultimately, it's not, you know, sort of merchandising or, you know, promotional work. It's actually going out and making the sales. And when I say going out, I mean they're customarily and regularly away from the employer's place of business. And that includes a remote office. So employees who are making sales over email or over phone or over video calls from your office or from their home office probably aren't going to qualify for outside sales unless they're also going out, right? Going out to meetings, going out to clients, going to trade shows, right? Like it's got to be a way, which got pretty complicated during COVID, right? When everyone was remote, there were some questions of, can everybody still be outside sales when nobody's away anymore? And that, I'm not sure if that ever really got resolved or if the DOL ever looked at it too closely. But it's definitely something that is still, coming out of COVID and remote work. It's important to remember that this is still part of the test.
And just kind of to piggyback on what Erin was saying, this is just another one of those where the duties that they have to be primarily most of the time away from their, whether it's home office or away from the company's home base office. They've got to be out at making sales calls.
Yeah. That's definitely one that gets tricky. And especially if some employees are going out and others aren't, you have to look at each role, right? And determine, is this person actually doing it as opposed to just the job title? All right. So we told you all about the new salary threshold rule. Again, that increase in July, the next increase in January, and then again in July 2027. But of course, that rule has been challenged. And so we're waiting to see what will happen with it. Several cases are pending in multiple federal courts. One case that has been in the news the most often is the state of Texas versus the United States Department of Labor, and others. In that case, Texas has said, hey, this rule wasn't, implemented in the right way. It's an overstep of the DOL's authority. And they asked the court to block the rule. So they filed a motion for a preliminary injunction and said, stop the DOL from enforcing this. As this case goes through litigation, nobody should be subject to it. And the court granted that motion just for the state of Texas as an employer. And so the DOL is blocked from enforcing this salary threshold rule only against the state of Texas as an employer and against those employees. I think it's like 88 employees who Texas said would be impacted and potentially, reclassified from exempt to non-exempt. For everyone else, though, the new rule is still currently in effect. That's, even other employers in Texas. Anyone who is not the state of Texas is currently subject to this rule and is subject to DOL enforcement of this rule. For now, right? So we're monitoring for updates. We're watching this case and other cases to see if anything's going to change. I don't have a crystal ball, but I would expect we'll see something before January 1st when the next increase happens, whether it's, for or against the rule. But we're definitely watching it. But as of now, the rule is $844 per week for those EAP exemptions and $132,964 per year for the highly compensated employee exemptions. So of course, if there's any updates, we'll publish client alerts on it and news alerts on it, and I'm sure other folks will too. So I wouldn't be surprised if you see news as there's any developments in the cases. All right, next we have some updates on DOL enforcement and litigation. So the DOL is, of course, active in enforcing the FLSA. It's specifically the wage and hour division is the division of the DOL or the US DOL that enforces these rules. And we just wanted to give an overview of some basics here. So,
yeah, and on this, I think Erin's going to go through like how we see enforcement, but this one is really focusing on the agency activity. The statute of limitations actually applies to individual claims as well. So just kind of keep in mind that there are various ways that the Fair Labor Standards Act is enforced. And so Erin's going to go through.
Yeah, so as Beth said, it's typically a 2-year statute of limitations. So that means when an employee brings a claim or when the DOL comes in and does an investigation or an audit or brings a claim, you're going back 2 years to see if overtime or wages are owed. Now, that statute of limitations can get extended to 3 years for willful violations. And willful is not as high of a standard as you might expect. The DOL will find willful violations, even if it's not like a evil intent, sort of we meant to harm our employees and steal their wages. There can be willful violations found in other situations too. Damages can include back pay and overtime, also liquidated damages, which is basically you double the amount that's owed. There can also be civil monetary penalties where the government will just collect penalties, even if it's not money owed to the employees. And there's also potential for individual liability, which can be pretty scary to hear if someone's a decision maker for the company, right? To hear that you could be individually liable. And as Beth said, there's multiple avenues for enforcement. The DOL can enforce, whether through an investigation that's prompted by an employee complaint, or sometimes just a random audit. There's also individual actions and collective actions. So collective actions are basically the FLSA version of class actions, where an employee or a group of employees brings a lawsuit on behalf of themselves and on behalf of others similarly situated employees. And if misclassification is found, it can be really costly. This was a recent award of back wages. $35.8 million was awarded to some healthcare workers in Pennsylvania. This was multiple employers, and of course, many employees. But here, a court found that the employers willfully failed to pay for all hours worked. So employees were working through meal breaks and weren't being paid. The employers failed to include non-discretionary bonuses and shift differentials when calculating overtime. They also incorrectly treated some employees as exempt when they should have been non-exempt. And finally, they didn't keep accurate records of hours worked. And so those record-keeping violations are really sort of low-hanging fruit for the DOL, right? Or for a court, if an employee brings a claim that they were misclassified, they were classified as exempt and they should have been non-exempt, and now they say they're owed overtime. If there's no hours recorded, it's really hard to disprove that, right? And technically, if they should have been non-exempt, the employer was supposed to keep hours. Keep records of hours. And so that's sort of one of those violations that just gets tacked on as a record-keeping violation. Another example, the DOL recovered $475,000. This was 32 employees of a restaurant group in Las Vegas. The employer wasn't combining hours worked at more than one location to calculate overtime. They weren't paying overtime. And there were 2 employees who were wrongfully classified as exempt when they should have been non-exempt. This is a good example of the liquidated damages. So the total back wages owed, like the back pay and overtime owed, was $237,692. And then that got doubled. And then there was also $12,000 in civil penalties for those willful violations. Another example, $288,979, including back wages, $15,000 in penalties. This was for 92 employees of a property management group. Here, the employer was claiming overtime exemptions for employees who were not exempt from overtime. They were shaving hours off of timesheets, and they were paying flat salaries and just failed to include bonuses and commissions in the regular rate of pay to calculate overtime, which is what Beth was mentioning earlier about having to include that pay when you're calculating what the regular rate is, because you use the regular rate to calculate 1.5 times the regular rate for overtime. Another example, $912,000 back wages and tips and liquidated damages. This was a tap room. We're not focused on talking about tips and tip pooling here. So our focus is really on the exemptions. Here they fell into the trap of saying, oh, our brewers and bartenders and administrative staff are paid on a salary basis, and so they're exempt. But this was a good example of, their duties didn't meet the duties test. And so just because they were paid salary did not mean they were exempt. As far as trends go, we're seeing sort of a lot of DOL activity, but overall, it looks like last year, fines were record highs, but actual enforcement actions were record lows since 2013. So it looks like they're sort of hitting hard, but targeting certain industries. So right now, they're targeting, food services and hospitality, construction, agriculture, and healthcare, especially home healthcare workers. We see a lot of actions in those industries. We're also seeing a rise in collective actions. So again, those sort of equivalents of class actions brought by multiple employees on behalf of all their coworkers. So Beth is going to talk a bit now about some best practices for auditing your employees' exemption status now that we've scared you with all those big numbers.
Thanks, Erin. So in all the years I've been doing this, I don't think I have ever met an employer who said, I'm intentionally am not going to pay my workers correctly. The regulations are dense, and sometimes they're vague. And, we, meaning those of us not working for Department of Labor, don't, often have insight on what, some specific roles that they think should fit in one category or another. Just kind of to throw a resource out there for you all. The Department of Labor does have what's called a field office handbook. It is available online, and that's often a good resource if you've got a really unique type of position to see if that has been addressed before, as whether it's an exempt role or not. But want to focus on, okay, so first of all, after hearing all this, we're hoping that you're going to come back, go back and take a look at your various roles and make sure you're meeting all the qualifications for the exemptions to overtime, including, all three for, the salary level test, the salary basis test, the duties test, make sure you're meeting everything. And once you do that, you just may find that there's some roles that you need to tweak. So let's talk about how to handle that. So I think when going back through an audit, I think our position, and it's consistent with the Department of Labor's, is start from the premise that your employee is eligible for overtime, and then prove yourself wrong. Make sure objectively you can prove yourself wrong that the employee actually is exempt, because the default position is that employees really should all be paid overtime for over 40 hours worked in a work week. So, and if you go at it from that position, that kind of a viewpoint of, all right, let me prove the exemption here. That's what we have to do when there's a DOL audit. So the DOL starts from that position. And, oftentimes what happens is I hope this never happens to any of you, or it hasn't happened to you, but a DOL investigator will show up at your place of business and say, I have a long list of very detailed information that would probably take you about a week to gather, and they want it all the next day. That's truly how it happens. So the first thing to do would be to call your legal counsel really quickly. And then we are typically there, the DOL works with us all very cordially, and we get, reasonable timeframes to get the data to them. But the DOL is going to look at every one of these positions with a lens of they're owed overtime. If they are exempt, then you, employer, have that burden of proof. So it's not that the DOL has the burden of proof. We, as the employers, have the burden of proof to prove the exemption for each and every employee if we're not paying overtime. So one of the things we're recommending is that when you're doing this audit, also go back and look at the job descriptions, because oftentimes the job descriptions, we're seeing like less and less good content in job descriptions, because there's like this trend for keep it really short and punchy, pithy for an Indeed posting or some sort of online posting, and then that becomes the job description when it's really not geared toward being able to prove that this is an exempt role. So I would just suggest to all of you that it's okay to keep that little short pithy thing, but you need to have a longer version of job descriptions that are accurate and up to date of what the job actually is. Because that's one of the things that Department of Labor is going to look for. And we just have not found it very helpful just to have those, couple of paragraphs that you see on Indeed or the other online postings to meet that burden. Another area that we really counsel clients to take a hard look at is, Erin mentioned before, is any sort of deductions in pay for employees or that affect employees who are classified as exempt. We have tons of debates with clients about, the wording of the DOL regulations of what do you do when someone runs out of PTO and those sorts of things. Just tread very carefully, and I would just encourage you on a case-by-case situation. If you have something come up, consult with your counsel, because the risk, you may really want to not pay them for 5 hours in a work week, but the consequences of getting that wrong and destroying the exemption for not just that role, but everybody else, is a lot more than the 5 hours. And so it might be much more prudent to deal with someone who's not working a schedule through a disciplinary measure. It might be much more cost effective, but that's again a topic with counsel on your case-by-case basis. Also, make sure that employees understand that they have a responsibility to track hours worked. We're going to kind of roll into some red flags that the DOL sees, but even if you feel very confident on the exemptions as you have made determinations on different roles, we recommend that you still have some way of, at least in a larger context, of knowing when folks are working. Because the DOL may not agree with us, and we need to have some sort of system, whether it's your for employees who work on site, whether it's your key fob, whether it's your computer login system, on knowing when folks work. Or we have some clients, and I think it's a good practice, where even their exempt employees do some sort of timesheet of, okay, I worked 8 hours today, or I took PTO, and I'm tracking that. Because if there ever is a dispute and DOL takes another position, decides the role is not exempt, we really need information that would go back for 2, maybe up to 3 years for every single week to figure out whether overtime is owed, because overtime is only paid for actual hours worked. So, you get holidays, you have vacations, you have folks on FMLA, and we have to, be able to look at each work week on its own. And, and so our challenge to you, because we know this is a challenge opportunity, is to make sure that you've got a mechanism for, at least in broad terms, knowing when somebody worked, how much they worked during a week, exempt or non-exempt.
Yeah, and I'll just add here, with remote employees or employees who are, maybe exempt and not tracking their hours, is it sometimes we'll hear, well, we can see when they log on and log off, but that doesn't mean that they were working the whole day, right? They might have still been logged onto the computer, or they might just leave it logged on for longer. And so that's not really like a good way to tell if somebody's actually working or not, but that's still better to have some record of when people may have been working, because if you have an employee come and say, I work 12 hours every day for the last year and I'm owed overtime, and you have nothing, that's worse than being able to say, well, we can at least see that they were only logged on 9 hours a day, and so we owe less overtime, or there were weeks where they never logged on, right? So being able to have records to refute or push back on what the employee says can be helpful, because if you don't have them, the DOL will take the employee's word, so long as it's not like completely unreasonable.
Yeah, so when you're going through and reviewing your roles, again, we're very much recommending look at the actual duties, get behind job titles. There's I know we don't want to have tons and tons of different job titles, especially if your organization is long, but Erin pointed out earlier that you could have situations where a person has a job title and may be exempt in one role, but have this, that person is exempt, but someone with the exact same title is not. They could be, you could have someone who supervises others. You could have someone who's, has, the role is actually different. So get behind the job title. And again, take a look at the requirements you've got, for these executive, administrative, and professional, as well as the highly compensated. You got to meet all three of these tests. It's not just some of it. You got to meet all three to win. So make sure that you're in good stead on that.
Yeah, and that's a good point about the actual duties and not just the job title. There are some jobs that are sort of the common, the high flyers we see of, business analyst, project manager, these sort of catch-all job titles that can often encompass multiple different duties for different employees. And so if you're looking at just the, category of job title versus each individual employee's duties, then, you may be missing some people who should or shouldn't be exempt.
So if you figure out, oh my goodness, I've got a misclassified employee, or, based on just the salary test from last month, do I need to make a change? And do I need to go ahead and make a change thinking about January? So we recommend that you're like very deliberate in how you go back. First of all, our recommendation is going to be that you remedy the situation. There's always a better outcome if the employer goes back and does a reasonable calculation of what overtime would be owed for, going back for a 2-year time frame, and then pay it. And we also recommend, figuring out what the interest rate was during that period of time, applying some interest to it, because that's what the DOL is going to do as well. And let folks know how you message that. I think you really need to strategize with your counsel about how you roll that out. Is it because the law changed? Is it because you found an error? It could be one of two things, but we would want to make sure the messaging is right. We don't want to, create some sort of evidence that may expose bigger liability than there actually is. So the wording is going to be key on how you communicate that to employees. So, Erin said last year there were not as many number of DOL investigations, but they're going for the big tickets, and they're focusing on industries, and they'll, continue to do that, and it'll evolve over which industries they're looking at. So some things that we have noted in working with clients through DOL investigations are some of these scenarios that just pop up a red flag for a DOL investigator. One is if nobody is classified as non-exempt. Everybody's on a salary, nobody gets overtime. We actually hear that from time to time from folks, and we're like, oh no, you can't do that. You know, you got to pay overtime. So make sure that that's not how your organization is. If that's the case, that something's probably amiss. That's very rare that you've got an entire organization and no one is eligible for overtime. That's, you know, because it's sort of backward than the presumption of you start off that everybody's not exempt. Another issue we see is that employers sometimes blow their own exemptions by paying employees who would otherwise be exempt on an hourly basis. Now, this is getting out of that computer exemption, but I see in the chat, one of the questions is, you know, why are nurse practitioners and nurses non-exempt? And yeah, it really goes back to the nature of the job. And you know, nurse practitioners actually can be exempt, but they got to meet all the other requirements. So, you know, we see a lot of roles where they're paid on an hourly basis, and that destroys the exemption. Or they're only working part-time, so they're not going to meet the salary threshold. There's all sorts of reasons why. And nurses, I would just tell you, DOL has decided decades ago that unless a nurse fits in that management role, that just a registered nurse is not going to meet the professional exemption. It's really reserved for the nurse practitioners, the physicians, you know, that higher level, higher level course of study. Another red flag for the DOL is if there are no time records. You know, everybody, you know, if we're turning over what are time records and everybody every day is reporting 8.0 hours, that's a red flag. So just, you know, either you have no time records or they're not particularly accurate. Everyone's just putting 8 hours on, you know, something like that. Those inside sales jobs, again, or, you know, was pointing out that gets a lot of scrutiny, as well as the assistant manager roles that Erin pointed out. IT roles get a lot of scrutiny, as do a lot of what I'm going to use the lowercase administrative office type jobs, whether it's, you know, HR or marketing type roles, that sort of stuff. So, you know, all of those on your end, best practice is just do a deep dive into the actual job duties to see if they're going to fit within an exemption. So we have a couple minutes left for questions. And before we do, I just want to note that the SHRM credit number will come up at the end of, you know, it's going to be the very last slide if you want to jot that down. We are going to also, we'll send out copies of this presentation for all of you who attended, and we'll be posting this presentation on our website. It takes us several days to get it up, but you know, it should be up by early next week. So any questions? I think there was one about the computer professional. I think, you know, it looks like that one was addressed. Nurses, nurse practitioners, any other questions while we have a minute or so? Here's a question. Are audits always because, let me get to the full question, and employee complaints, or can they be random? They can be both. They can be just DOL shows up one day and you just hit their radar, or it could be because of a complaint. Either way, don't ask the investigator, because we really don't want to know if it was as part of a complaint, because then we don't want a retaliation claim by the employee who, you know, we suspect turned it in. That's a good question. All right, thank you, everybody.
All right, we're going to
more.
switch to the SHRM.
Okay.
Oh, we've got one more question.
Yeah, one more question. Most of our references to the Department of Labor were federal because this was really focusing on the Federal Fair Labor Standards Act. With the two different departments work a little bit differently as you know, as far as what their requirements are. So it's, and there's a note here that only the North Carolina DOL requires employer proof of hours worked. So and that's very true. That's just another reason to keep good time records.